Hello and welcome to our Procurement Act Insights podcast series. The Procurement Act 2023 marks a significant shift in public procurement in the UK, introducing new procedures, obligations and opportunities for local government. Whether you're working in procurement, part of the legal team or commissioning, it's essential to understand what these new changes mean in practice. To support you through this transition, Sharp Pritchard procurement specialists have created a series of short sessions designed specifically for local government to help you understand and apply the new procurement rules. Each session has a voiceover from our procurement experts with easy to follow slides, is relatively short, 30 to 40 minutes, and can be accessed on demand and returned to at any time, so perfect for busy teams. After a long and winding road since Brexit, the new procurement reforms finally went live on 24th of February 2025. The material in this presentation is based on the Procurement Act 2023 and the Procurement Regulations 2024 and related material valid at September 2025. We've tailored the content of each episode to focus on key PCR 2015 related changes relevant to local government, but do be aware that there are some differences between local government and central government procurements, and also for the defence sector, and for utilities, private utilities, and for utilities contracts. We hope you enjoy our insights.
In this session today, we will be looking at pre-procurement considerations under the Procurement Act 23. And so today we will be covering the topics of the pre-procurement checklist, preliminary market engagement, consideration of lots, record keeping, conflicts of interest, and finally we'll have a quick look at some of the reading material we would recommend for these topics. Firstly, the pre-procurement checklist. So this is a standard template that the GCF have published, and it is on their procurement pathway tool website, which we've set out there on the right-hand side of the screen. And it is a standard template. It isn't mandated, but it is a tool and it's recommended for best practice. What it does provide for you is a checklist of things to be thinking about and considering at the outset of procurement and planning your procurement. It has 4 different sections: the requirement, the procurement process, governance, and logistics. And the suggestion is that you go through each of those topics and each of the items within those and check the box of each section. If a section isn't checked, you're suggested to provide some supporting information in the comments box, really just for your own record and to keep an audit trail that each of these things have been considered and or why they haven't been relevant or considered in the particular procurement. So on this slide now, we've just set out some examples of the items on that checklist under each of the 4 sections. This isn't an exhaustive list, and we've just drawn out a few that we thought would be interesting to flag. So under the requirement section, one of the items on the checklist is that the contracting authority should check against wider policy requirements, including its internal ones, as well as wider nationwide requirements such as the National Procurement Policy Statement. And it's a good juncture to just remind everybody that at this point, Section 12 of the PA23 is very relevant, and that's around the objectives that start applying to covered procurements right at the outset of any procurement, including, for example, when you're carrying out preliminary market engagement. So this is the right time to be considering that duty. Also, alongside that, the overarching duty of contracting authorities to have regard to Section 13, the National Procurement Policy Statement, and Section 90 of the PA23 as well, which talks about non-discrimination against treaty state suppliers. So these are the sorts of policy requirements and principles that would be good to be thought about at this point, and the checklist flags that for you and reminds you of those things. The checklist under the requirement section 1 also talks about considering whether the requirements that you're about to put out to procurement should be subdivided into lots, and we'll think about lots in a little bit more detail later on in this session. In section 2, the checklist moves on to the procurement process. And here, one example of an item on the checklist is that the contracting authority ought to check that all transparency requirements are complied with. most obviously the publication of required notices under the PA23. It also suggests that you consider that your preliminary market engagement has been carried out in a way that doesn't give a supplier an unfair advantage. And this topic is also something we will come on to in a minute. Section 3 is titled Governance. Here it asks you to consider both internal and external approval requirements. It also suggests that you ensure that you have a robust process for capturing and systematically recording material procurement decisions and communications. This topic of record keeping is also something we'll talk about later on in this session. And finally, section 4 is labelled logistics. So examples of some items on the checklist include checking that your procurement timetable is realistic and proportionate, checking that you've got your e-procurement portal, whichever one you're using, ready and is suitably managed and resourced by people on your team, ensuring that individuals lined up to be tender assessors have been identified and their time secured, and ensuring alongside that their conflicts of interest declarations have been completed. And conflicts of interest is also something that we will cover later on in this session. Just a quick reminder then of some of the notices that are required under the PA23 that are particularly relevant to this particular stage. First of all, the planned procurement notice. While this is optional, it is used to give notice to the market in advance of the actual tender notice being published. If it is published within certain prescribed timescales set out in the Act, Section 15, it can also be used to reduce tendering periods. The other notice that is relevant to this stage is the pipeline notice, and this one is applicable where contracting authorities expect to pay more than £100 million under relevant contracts in the coming financial year, and it is relevant in relation then to any procurements that are over 2 million. In practice, although this is a pipeline notice meant to give sight of the contracting authority's entire procurement pipeline, each procurement that is over 2 million will need to be recorded and a notice entered into on the digital platform individually. So therefore, this is something that needs to be considered each time a procurement is being prepared. The final notice that we want to flag at this point is the preliminary market engagement notice, and this one is used to notify that market engagement will be or has been carried out. We talk about other notices in our transparency episode of this webinar series, so look out for that for more on notices.
Moving on to preliminary market engagement. Procurement Act Section 16, subsection 1 provides a definition of preliminary market engagement. This states that before publishing a tender notice, a contracting authority may engage with suppliers and other persons for the purposes of developing the authority's requirements and approach to the procurement, designing a procedure, conditions of participation or award criteria, preparing the tender notice and associated tender documents, identifying suppliers that may be able to supply the goods, services, or works required, identifying likely contractual terms, or building capacity among suppliers in relation to the contract being awarded. The form or structure of preliminary market engagement is less important than the content. If you are engaging in any of these activities, it will be treated as preliminary market engagement, and contracting authorities will need to comply with the relevant provisions under Procurement Act. There's no requirement to carry out market engagement, but if a contracting authority does so, then it must either publish a preliminary market engagement notice or explain in the tender notice why market engagement was conducted without publishing the notice. Procurement Regulations 2024, Regulation 17, provide the form and content for preliminary market engagement notices. The relevant regulation is Regulation 48 for private utilities. And this lists the information that must be included in preliminary market engagement notices. This includes details of the procurement, the date when the contracting authority intends to close the market engagement, or the date that it will be closed, and a description of the process by which contracting authorities proposes to engage or has engaged with suppliers, such as the location, date, time of the event, and any periods for the submission of expressions of interest and information. Where undertaking preliminary market engagement, contracting authorities have a duty to take reasonable steps to ensure that suppliers participating in market engagement are not put at an unfair advantage and that competition is not otherwise distorted. Now, that's set out under Section 16, subsection 3 of Procurement Act 2023 and contrasts slightly with the equivalent obligations as per public contracts regulations. Procurement Act 2023 provides a series of steps that must be followed if preliminary market engagement is undertaken and results in a supplier gaining an unfair advantage. The steps are set out as follows. Section 16, subsection 4 applies if a contracting authority considers that a supplier's prior participation in market engagement gives it an unfair advantage that cannot be avoided. In such circumstances, Section 16, subsection 5 applies, and this requires the contracting authority must treat the supplier as an excluded supplier for the purposes of assessing tenders under Section 19 for competitive awards, or awarding a contract under a direct award procedure pursuant to Section 41 or 43. In addition, the contracting authority must exclude suppliers from participating in or progressing as part of the procurement. It's important to note here that this mechanism applies for the purpose of that procurement. It does not carry with it the broader consequences of a supplier being designated an excluded supplier more generally, as set out in sections 57 and 59 under the Procurement Act 2023. To summarise some of the changes from the previous procurement regime, the Public Contracts Regulations 2015, as we touched on initially on this subject, Procurement Act 2023 has a fuller, broader definition of preliminary market engagement compared to what we had under Public Contracts Regulations. The definition under PCR, as by way of a reminder, applied to simply market consultations with a view to preparing the procurement and informing economic operators of procurement plans and requirements, and contracting authorities were allowed to seek or accept advice from independent experts or authorities from market participants. The broader list of activities that is covered by preliminary market engagement may be helpful for contracting authorities if they are unsure about the topics or subjects of preliminary market engagement, and may provide greater confidence to speak with suppliers about the activities referred to in section 16, subsection 1, set out on a previous slide. The second point to note around the differences from the previous regime is that in Public Contracts Regulations, Regulation 41.2, it specified specific measures that contracting authorities can take to avoid distortion of competition where undertaking market engagement. There aren't any equivalent measures specified in Procurement Act 2023. However, technical guidance that was issued in the run-up to Procurement Act going live does state that those measures that were provided for in the PCR, i.e. the sharing of relevant information and setting adequate time limits, can still be adopted for Procurement Act 23 procurements. And lastly, we talked on the previous slide about the need to potentially exclude a supplier if it results in an unfair advantage. Under Procurement Act 23, there is not an express requirement to the one that was in public contracts regulations to give the supplier an opportunity to prove that their prior involvement does not distort competition. The technical guidance published by Cabinet Office in the run-up to Procurement Act going live sets out some quite helpful comments on how to conduct preliminary market engagement in a way that does not put a supplier at an unfair advantage and to avoid competition being distorted. It's also important to ensure that you remember the Section 12 procurement objectives in addition. The guidance helpfully points out that contracting authorities should consider how you're going to conduct preliminary market engagement in a way that does not result in a supplier gaining an unfair advantage or distorting competition before you undertake the engagement. Keep a record of information that's shared and received, and share relevant information with other parties. It would be best practice to do so in the tender notice or other tender documentation. And contracting authorities may be able to use market engagement as a tool to consider whether any particular barriers to participation in the procurement are faced by SMEs and how those could be removed. Of course, it is extremely important to ensure that those suppliers do not gain an unfair advantage or distortion of competition. And just to provide a few examples on what might be considered to be preliminary market engagement, as touched on earlier, engagement can be formal or informal. If the purpose is caught by the list set out in Section 16, subsection 1, it must be treated as preliminary market engagement. And the guidance highlights a few tools and methods of market engagement. And if you are wishing to undertake some market engagement but not sure how, it could be undertaken through a variety of means, including questionnaires, hosting a supplier day, meeting with suppliers, having face-to-face presentations, or webinars, workshops, or site visits. And lastly, on this subject, a point to note that the pre-procurement checklist published through the procurement pathway tool has a checklist section dealing with preliminary market engagement as a prompt for contracting authorities using the checklist to ensure that they are comfortable they've conducted their market engagement in a way that complies with the Procurement Act provisions.
We will now move on to the consideration of lots, which is another item on the pre-procurement checklist. So Cabinet Office guidance on lots explains that under the PA23, the requirement to consider lots and whether a requirement should be split into lots is strengthened by the specific SME duty. In other words, the duty to consider whether barriers to participation in a covered procurement can be removed or reduced. We're referring here to the Section 12, subsection 4 duty under the Act. A quick side note here just to say that Cabinet Office guidance, which we refer to several times in this presentation, is described as technical guidance. It isn't statutory guidance, and therefore in the event of any potential conflict between the legislation, for example, the PA23 itself, and the guidance, it will be the court's interpretation of the legislation itself which will prevail. In any case, the guidance provides a lot of practical guidance, so we will continue to refer to it throughout the session. So the second point on the slide notes that there continues to be, as there always has been, a duty to consider whether a public contract can be divided into lots. Under the PA23, there's also still the need to provide reasons for not splitting a procurement into lots, other than for light touch contracts and utilities contracts. It is also still possible to limit the number of lots that one supplier can be awarded, and this just needs to be set out in the procurement documentation really clearly at the outset. In terms of notices related to lots, a reminder here that for the tender notice, that is one of the first notices you will be publishing, it is important to state whether the contract is split into lots, and if it's not, the reasons for not doing so. a description of each lot, and also whether there are any restrictions as to the number of lots that one supplier may tender for or be awarded. The next time that lots will be applicable in a notice to be published under the PA23 would be your contract award notice, and this is the one that's published prior to entering into the public contract, and this will need to also include a reference to the contracts awarded for each lot. With both the tender notice and the contract award notice, a single notice can be used and published to cover all the lots that are relevant to that particular procurement. However, the final notice on the slide, the contract details notice, this is published once the contracts have been awarded. Now, this includes a description of the goods, services, or works which will be supplied under the lot and under that successfully awarded contract, and also will provide the estimated value of each lot. And due to the nature of what this notice does, it is one notice that needs to be published per public contract awarded.
The next section of our talk is about record keeping. Section 98 of Procurement Act 2023 requires that contracting authorities must keep such records as it considers sufficient to explain a material decision made for the purpose of awarding or entering into a public contract. A decision is material if, under the Act, the contracting authority is required to publish a notice, document or other information in relation to the decision, or is otherwise required to make a decision. In addition, contracting authorities must keep records of any communication between the authority and a supplier that's made in relation to the award or entry into of a public contract, and communications with the supplier before the contract is entered into. The record must be kept and stored until the day on which the contracting authority gives notice of a decision not to award a contract, or where the contract is awarded 3 years after the date on which the contract is entered into. Now, this obligation doesn't apply to defence or security contracts and does not affect any other obligation under any other rule of law that requires the contracting authority to retain documents for any longer period. A technical guidance published by Cabinet Office alongside Procurement Act 2023 provides some further commentary and insight as to what records need to be kept in relation to above threshold contracts. This explains that records need to be sufficient to explain a material decision that's made during the award of that contract, and records of any communication with suppliers made in relation to the award of the contract. The GC talks about what types of decisions are going to be material, and in our view, the wording doesn't quite align with that's found in the Procurement Act itself, and therefore do refer back to the source material, i.e. the legislation, when considering whether or not a decision is or is not material. Nevertheless, some of the examples given in the cheat sheet include decisions that are made by the contracting authority as follows. Exclude whether or not you're excluding a supplier based on a mandatory or discretionary ground of exclusion, excluding or reducing the number of suppliers based on conditions of participation, conducting an interim assessment to reduce the number of suppliers during a competitive flexible procedure, the assessment of tenders against the award criteria, or the decision to award a contract, or if applicable, to terminate the procurement without awarding a contract. And lastly, for record keeping, the cheat sheet includes a template that is optional for contracting authorities to use to assist them with their record keeping obligations, and this is displayed on screen.
We move on now to our final topic for this session, which is conflicts of interest. Under Section 81 of the Procurement Act 23, there is a duty to identify conflicts of interest. So what that means is that a contracting authority must take all reasonable steps to identify and keep under review in relation to a covered procurement as defined in the Act any conflicts of interest or potential conflicts of interest. And what that means is that there is a conflict of interest under the Act if a person and also if a minister acts for or on behalf of the contracting authority in relation to that specific procurement. If such a person has a conflict of interest, there is a conflict of interest. Now, an interest may include a personal one, a professional one, financial interest. It can also be direct or indirect. In other words, the concept of conflicts of interest and interests in general under the Procurement Act is wide. In terms of firstly how that contracting authority can take a reasonable step to identify such interests, the template declaration of interest form that's available on the Procurement Pathway Tool website we referred to earlier is a useful way to start. It provides a clear form that sets out what an individual should declare in terms of an interest. It provides the format and platform on which an individual who's working in relation to a procurement can set out any conflicts they consider they might hold. This, I think, is a clear and reasonable way to demonstrate that a contracting authority has discharged that first duty to take all reasonable steps to identify any conflicts among individuals who are acting on its behalf in relation to the procurement. Also, if kept updated and refreshed, it would also enable the contracting authority to carry out the obligation of keeping conflicts under review. Section 82 then of the PA23 talks about the duty to then mitigate conflicts of interest. What it says is that a contracting authority must take all reasonable steps to ensure that a conflict of interest does not put a supplier at an unfair advantage or disadvantage in relation to a covered procurement. It then goes on to say that reasonable steps may include requiring a supplier to take reasonable steps themselves to mitigate that conflict. In terms of the steps then to ensure that a contracting authority is complying with sections 81 and 82, firstly, under section 82, subsection 3, if the contracting authority considers that a conflict of interest puts the supplier at an unfair advantage that cannot be avoided, or the supplier will not take steps that the contracting authority considers are necessary to ensure it's not put at an unfair advantage, then you move on to section 82, subsection 4, whereby the contracting authority must firstly treat the supplier as an excluded supplier for the purpose of assessing tenders under section 19, or for awarding a contract under section 41 or 43. And secondly, it must exclude the supplier from participating in the procurement. And very similarly to the topic around prior involvement in the procurement and any unfair advantage there are some nuances here under section 82.4 as well, in that this requirement for the supplier to be treated as an excluded supplier does not link up with section 57 or 59 of the Act in relation to excluded suppliers more generally. Similarly, it doesn't expressly link up to section 27 and that use of the term excluded supplier. So section 82.4 is a mandatory exclusion ground, but needs to be looked at in its own right. In terms of key differences between the PCR 2015 and the new Act on conflicts of interest, whereas under PCR 2015, Regulation 24, subsection 3 expressly required a contracting authority to address conflicts issues held by what they referred to as relevant staff members, and then that was further explained as being individuals who are involved in the conduct of the procurement procedure or may influence the outcome of that procedure. Section 81, subsection 2A under the Act applies the conflict duty in relation to what is referred to as a person or minister acting in relation to the procurement. Now, the Act then doesn't specify what that doesn't then expand on what that means, but the guidance issued by Cabinet Office on conflicts of interest does state that a person acting in relation to a procurement is doing so if they are in a position to influence a decision made by or on behalf of a contracting authority. In other words, there is a nuanced but clear shift of focus from somebody who's influencing decisions as opposed to someone who was influencing the outcome, which was the wording in the PCR. potentially results in a net broadening of the duty, we think, when taking the guidance into account. Now, under the Procurement Act, a conflict of interest may give rise to a mandatory ground of exclusion, as just explained, and it does now expressly state that a step to manage a conflict of interest may require a supplier to take steps, and a requirement to exclude a supplier if it does not take steps that the authority considers unnecessary. And finally, a key new requirement under the Procurement Act and in respect of conflicts of interest is the requirement for a conflicts assessment to be undertaken before publishing a tender or transparency notice.
Contracting authorities are now required to keep a conflicts assessment required by Section 83 of Procurement Act. And the conflicts assessment must include details of conflicts of interest or potential conflicts of interest that have been identified in accordance with Section 81, the duty to identify conflicts, and steps that have been taken or will be taken pursuant to the duty to mitigate conflicts under Section 82. In addition, the conflicts assessment needs to include details of perceived conflicts that have been identified and the steps that have been taken or will be taken to demonstrate that no conflict or potential conflict exists. It's worth highlighting here, as per the government commercial function guidance, the steps that you need to take to demonstrate you've managed a perceived conflict of interest do not need to eradicate all doubt as to whether or not a conflict may exist, but you do need to demonstrate to a reasonable person that there is no actual or potential conflict. Conflict assessments must be kept under review and revised as necessary. There's an express requirement when publishing a relevant notice to confirm that conflicts assessment has been prepared and revised. The relevant notices are a tender notice, a transparency notice, a dynamic market notice, a contracts details notice, or a contract change notice. This duty to keep under review and revise conflicts assessment ends after either the contracting authority has given notice of its decision to not award a contract, or if a contract or dynamic market is established, this duty will continue until the contract is either terminated or the dynamic market ceases to operate. So for successful procurements, the conflicts of interest duty will last for the life of the contract or dynamic market, not just the life of the procurement process. There isn't any prescribed structure or format for a conflicts assessment. There is a template that contracting authorities can use, and that's provided for in the procurement pathway tool published by Government Commercial Function. Guidance on what to include in your conflicts assessment says that subject to procurement legislation, it would be good practice to include details of the individuals or teams that are relevant to the procurement and their roles, how those individuals or teams are relevant to the procurement, whether the required conflicts declarations have been received, whether any actual, potential, or perceived conflicts have been identified, and if so, to provide details of those conflicts, what mitigation steps have been applied or taken or will be taken if needed in the future, whether following any mitigation steps a supplier remains at an unfair advantage or disadvantage, and when the conflicts assessment was last reviewed and the date of the next planned update. Some other instances where it may be necessary to update and review your conflicts assessment in addition to the time at which you're publishing a relevant notice would include when additional people acting for or on behalf of the contracting authority are identified who will have an influence over a decision in relation to the procurement. Obviously, the change in people running the procurement can trigger a need to freshly consider whether or not conflicts of interest have been identified and whether or not new mitigations are needed. Another instance of where you may need to review your conflicts assessment is if you move to the next stage of a procurement process and new information becomes available. For example, once you're past the shortlisting stage, you may have identified additional suppliers who are taking part in the procurement that hadn't been considered for conflicts at an earlier stage. I mentioned previously a template conflicts assessment that is available for use. It's not mandatory. Your contracting authorities can use a different form, but nevertheless, it is quite helpful to refer to the template if you are designing your own processes and procedures and templates for managing conflicts in your procurements. We won't intend to talk through every aspect of the form. It's quite short and concise. I'll show you the other parts now. On the slide here, we have a reminder of the overarching principles of procurement that contracting authorities should have regard to for covered procurements. Section 12, covered procurement objectives. Section 13, National Procurement Policy Statement, requires contracting authorities must have regard to the NPPS. And in carrying out a procurement, not just a covered procurement, Section 90 requires contracting authorities to observe the rules around treaty state suppliers and non-discrimination. Contracting authorities cannot discriminate against treaty state suppliers. And finally, we have on this slide set out all of the different reading materials that we've referred to throughout this presentation, which you may find useful if reading further into conflicts of interest and other related subjects we talked about.
So, we hope you enjoyed this episode of our practical insights into the Procurement Act. Please do listen to the rest of the series for more insights relevant to local government. If you want to discuss any issues raised in this episode, or if you need assistance with a procurement matter, please do get in touch. Thank you for listening.